There's a lot of work to do. And as a matter of fact, this is quite appropriate and coincidental in time, because the Chief Justice is asking Justice Shona Griffith to chair a family law reform committee that they're putting together. And myself and now senior counsel as well, Roberta Magnus Usher, have been asked to serve on that committee, which I would hope we're happy to, I haven't spoken to her yet, but certainly I will be there to put my 2 cents. Let me give you an example of one issue in family court that is still very much awful. I've been pushing for the law to be changed for years now, and we haven't seen any response yet, but it has to be done. Because there are 2 pieces of legislation that you'll use in the family court, the Married Persons Protection Act and the Families and Children's Act, they're different. Under the older Married Persons Protection Act, children can be maintained up to the age of 16 within a marriage. And then after 16, no more maintenance, but they're still in school. And if you do not apply before the child reaches the age of 16 to have the maintenance of that child extended, you're out in the cold. Whereas in the Families and Children Act, maintenance for children is up to the age of 18. So that is one instance in which common law has an advantage over the married parents, But who is it affecting? The children. But to repeat, in the Families and Children's Act, children can be maintained up to the age of 18 and even beyond. There is a section in the legislation that is saying you can be maintained even beyond the age of 18 if you're enrolled in a full-time course of study up to age 21. So that is good. The laws are there, but we have to implement them. And we also have to do what you call the meshing, or the putting together of the laws. And these are some of the things that we will look at. Plus, our divorce legislation, our practice before the Supreme Court. You have old matrimonial causes rules, but then you have other rules that are more modern. We have to try to harmonize. That's the word I wanted. We have to try to harmonize those pieces of legislation, because even before the Supreme Court, right now there are many difficulties. The Attorney General recently at the opening of the Supreme Court in January was saying, why is it so hard to get a divorce? If you can get your marriage license, or you publish your little banns or whatever, but mainly it is getting your marriage license, you could go right down to the registry with 2 witnesses and get married. Why is it you have to be accusing the other one of adultery and big shimmy-dimmy and, accusing desertion, accusing cruelty, when really it is a contract that should be broken the way it is made? And so those are some of the things that we need to look at. Because marriage, and here I put on the hat of lawyer now, and not a faithful of a particular religion. A marriage is not that you go to church, A marriage is that you sign, 2 people sign at the registry or within the church, but it's the signing and that contract that you make which makes you married. And we ought to be able to break that easier than waiting 3 years of separation now and everybody miserable in the meantime.